Welcome, everybody. My name is Ed Iacobucci. I'm the Dean of the faculty here, and it's my pleasure to introduce you to the Morris A. Gross Memorial Lecture and to welcome Chief Justice George Strathy of the Ontario Court of Appeal. It's a delight and an honor to have you back at the law school. He is an alumnus and has been through on a number of occasions of late, including speaking to our students. So it's very nice to have you back here. A little bit more about the Chief Justice. He was appointed Chief Justice in 2014 after being appointed to the Court of Appeal in 2013. For the previous 5 years, he had been on he was a Justice of the Superior Court of Justice. He received his BA from McGill, won a Woodrow Wilson Fellowship, and did graduate studies with that fellowship at the University of Toronto, where he got a Master of Arts in International Relations. He then came to the Faculty of Law, as I mentioned, and he squeaked through with the gold medal, graduating in 1974. In practice, he specialized in civil litigation with a particular emphasis on maritime and transportation law. Beginning his legal career at McKinnon McTaggart, a firm he has described as a kind of cradle for the judiciary, and which also saw the likes of other distinguished U of T graduate who became justices. Justices Robert Sharp and Ian Binney also were at that firm. He's been a partner at Campbell, Godfrey & Lutis and Fasken Martin Walker, and then established his own firm in 1991. The title of his lecture today is Judicial Courage and Restraint in Canadian Constitutional History. Both qualities of courage and restraint he's displayed from the bench. So for example, he joined a unanimous decision striking down as unconstitutional the Truth in Sentencing Act, and on another occasion joined a majority upholding legislation revoking voting rights for expat Canadians after a certain length of time. I will leave it to you to decide which was courageous and which displayed restraint, but lest you jump to conclusions, let me just observe that the voting decision attracted the attention of the Asper Centre, which was prepared to intervene in favor of the dissent at the Supreme Court of Canada, suggesting that upholding legislation displays some courage as well as striking it down. So I don't expect the Chief Justice to engage in any lengthy comment on either of these decisions, but I do very much look forward to hearing his views on the role that the judiciary has in the history of Canada's constitutions. In addition, as he has observed on other occasions, everything you need to know about law you can learn from admiralty law, so I am expecting one or two nuggets from admiralty law in this talk as well. But Chief Justice Strathy, welcome.
Thank you. Thank you very much. Thank you.
Thanks for joining me.
Thank you, Dean, for your kind words. It's wonderful to be back at the University of Toronto, the scene of many crimes some 40 years ago. I'd like to begin by acknowledging those responsible for this event. First, the family of Morris Gross, who established this lecture series. I didn't know Mr. Gross in practice, but one of my colleagues told me he was one of the finest lawyers and one of the kindest human beings he'd ever met. And it's also an honor to be here to launch the Asper Center's Constitutional Roundtable, which marks this year's sesquicentennial. When Professor Milne invited me to give this lecture on constitutional history, I must confess that my initial reaction was, why me? Why me? The Court of Appeal for Ontario, on which I sit, has some of Canada's finest constitutional jurists. One of my colleagues has been a judge since pre-charter days. Several have been on the bench more than 25 years. We have amongst our ranks 4 former law deans, several former law professors, all of whom, as well as any other members of the court, have written, lectured, and adjudicated extensively, far more extensively than I, in constitutional and charter issues. So why me, a practicing lawyer for 30 years with a specialty area in maritime law, an area where constitutional issues rarely arise? To the Dean's point, I I did arrest a few ships in my day, but ships don't have charter rights, so I didn't deal with the charter in my maritime law practice. But after thinking about Professor Milne's invitation and still asking why me, I decided to accept the invitation because it would give me an opportunity to reflect on some of the challenges associated with judging in the charter era, and to speak about some cases and some issues and some judges that I find particularly interesting. So the title of my remarks is Judicial Courage and Restraint in Canadian Constitutional History. And just by way of preface, let me tell you a little bit about my judicial introduction to the Charter. After my appointment to the Superior Court in 2007, I did primarily civil work, but one of the first cases I encountered, really within the first couple of months of my appointment, was an application brought by the Ontario Association of Justices of the Peace for a declaration that their Section 15 charter rights had been infringed by mandatory requirement provisions, which required them to retire at age 70, as opposed to age 75, which was available to provincial court judges. So here was this charter case landing on my desk that I had to decide. I read mounds of materials, a lot of affidavits, a lot of case law. I heard extensive submissions from some very good lawyers. And then I sat down and studied the materials and the law and the submissions for about 3 months, and ultimately released a decision finding that the legislation violated the Justices of the Peace's charter rights, that the provision could not be justified under Section 1, and that the appropriate remedy was to read into the legislation the retirement provisions applicable to Justices of the Peace. Now, to be quite candid, it was a fascinating case for me. Here I was, a newly minted judge with very little background in the charter, at least, and being tasked with the responsibility of deciding the employment rights of some 350 judicial officers and the responsibility to decide whether the provincial legislation was lawful. Fortunately for me, the decision wasn't appealed. It seemed to me that what the Attorney General really wanted was a determination of the judge's rights. The legislation was in fact amended, and it seems everybody was happy. So I continued my work in the civil field for about 5 years. Fortunately, I did some criminal law work in the last 9 months or so of my term as a Superior Court judge, and I dealt in those cases with what I might call street-level charter issues under Section 7 through 12 of the Charter, which were part of the daily fare of the trial court. But since joining the Court of Appeal, where more than half our appeals are criminal, and where our cases are driven by legal rather than factual inquiries, I've been confronted with charter issues frequently, but still that doesn't qualify me as a constitutional law expert. I will mention briefly 2 cases, and in fact they're the same 2 cases the Dean mentioned. I don't mention them to suggest that I displayed any of the qualities that I'm talking about today, nor do I intend to get deep into the cases, but I want to mention them simply as a way of explaining my own, or part of my own evolution as a judge. The first case was called the Queen and Safarzeti and Marcali, which addressed certain provisions of the Truth in Sentencing Act, which prohibited a sentencing judge from giving certain repeat offenders enhanced credit for time in pre-sentence custody. With a panel of 3 judges, I wrote a judgment striking down a portion of the Truth in Sentencing Act because it violated Section 7. Now, that decision was heard, or the appeal was heard before my appointment as Chief Justice. It was released shortly after my appointment. And it prompted a National Post columnist to write an article suggesting that I, as a newly formed Chief Justice had struck a blow for the judiciary by kicking the government in an uncomfortable place. The suggestion being that although I was appointed by that government, I had acted in a way that was confrontational to them. And to be frank, in this room, I think the only person that was uncomfortable by that article was me. I saw it, and I think my colleagues saw it, as simply as doing the job that we were supposed to do and that we were sworn to do, and where we believe the law and the facts took us. I have to say that I drew some comfort from the fact that my colleagues on the decision were Justices Mark Rosenberg and David Watt, two of the wisest and preeminent criminal law jurists in the country. Nevertheless, the columnist did make a point, and that is that we judges in Canada really do enjoy judicial independence, and we are not, nor are we expected to be, beholden to the government that appoints us. The second judgment was the one the Dean mentioned as well, the voting right case, and writing for the majority in a rather unusual split decision, I upheld federal rules that prevented some non-resident Canadians from being able to vote. We found, the majority at least, found that the rules violated Section 3 of the Charter, which gives every Canadian citizen the right to vote in a Canadian federal or provincial election. We found they violated Section 3, but we held that they were justifiable under Section 1. My highly respected colleague, Justice John Laskin, wrote a very vigorous dissent, and the Supreme Court of Canada granted leave to appeal. As you may know, the government has announced its intention to amend the legislation, and I understand the appeal has been adjourned to 2018. Whether it is heard or not remains to be seen. So as I said, I don't put these decisions forward as examples of any courage or restraint on my part. I think what they do show, though, is the two sides of the judicial spectrum in constitutional decision-making. In the one case, the court found in favor of a charter claimant, striking down a portion of the criminal code. And in the other case, the court found against the claimant, upholding the government's rules. I think one of the challenges for the judiciary is obviously knowing when to act and when not to. And I think, as the theme of my paper indicates, this challenge can be viewed through the lens of judicial courage and restraint, both of which I regard as judicial virtues. But I hasten to add, and I think we need to keep in mind, that when improperly exercised, judicial courage can become arrogance, and restraint can become timidity. Courage and restraint on the part of the judiciary help to preserve our democracy, and judicial arrogance and timidity harm it. So I propose to speak this afternoon about how these virtues can be used to construct a narrative about some legal doctrines, judicial decisions, and personalities in Canadian constitutional history. And I will suggest that the judicial role in Canada's constitutional history can be viewed as an attempt to balance these two virtues. I'll begin by explaining the meaning of courage and restraint and the challenges that we judges face in trying to define and exhibit these values. Against that backdrop, I'll discuss how the challenge has played out in both pre-charter and post-charter cases. So let me start with judicial courage, which is related to judicial independence, the separation of powers, and the rule of law. Judicial independence means independence from interference by other branches of government on public law adjudication. It demands separation from the other branches to enable the judge to render decisions based solely on the requirements of law. It extends to all courts as an unwritten principle derived from Canada's inheritance of a constitution similar in principle to that of the United Kingdom. Independence from other branches of government and the judge's ability to decide based only on the dictates of law are essential to resolving disputes over whether the state has acted within legal limits on its authority. If courts were to endorse all state actions, even if unauthorized by law, individuals would have no protection against arbitrary power or infringement of their rights. However, I think we should distinguish between the external objective institutional safeguards of security of tenure and administrative freedom that foster judicial independence, and the subjective state of mind that judges cultivate to ensure their own independence. Judicial courage is an internal and personal virtue. Judges are at times called upon to make unpopular decisions, to say unpopular things. This isn't confined to constitutional or charter issues. It happens day in and day out in all our courts. Judges have to strive to set aside their personal values, in the case of charter decisions, their personal values for or against state goals, their own opinions, and the opinions of members of the public and the media who may be clamoring for a particular outcome. Judges are called upon to decide autonomously in accordance with their faithful understanding of the law, even if the personal or political costs of doing so are high. Courage refers to a judge's duty to make independent and impartial decisions and to apply the law as he or she understands it without fear or favor and without regard to whether the decision is popular or not. I don't think we can, any of us, excise our own personal experiences from adjudication. But courage rejects timidity in the face of external forces that would foreclose a judge's mind to the requirements of the law and to competing perspectives. One of Canada's great constitutional jurists, Justice Ivan Rand, who I'll be speaking about a bit more shortly, said this in an article entitled, 1951 article entitled "The Role of an Independent Judiciary in Preserving Freedom." Quote, "There are alien factors that unconsciously may disturb the natural freedom of judgment and distort the process of adjudication. Bias, favorable or hostile, a sense of obligation, fear of disapprobation, a weakness for applause. There is the loyalty to class or church or party, the personal preference or dislike, the impulsive reaction of set notions. To be aware of mental domination of these and like ideas, to appreciate their possible irrelevance and danger, and to achieve a power of neutralizing them through mobility of mind in orienting itself to any group of assumptions is the condition of subjective independence." Now, I don't know whether, that's unquote, I don't know whether Justice Rand was speaking personally. I suspect he might have been. According to his biographer, Rand had some personal views that I think all of us would find repugnant. Yet, when I read his judgments, and to use his words, he seemed able to neutralize his personal views through what he described as a mobility of mind. Before I move on to restraint, I want to make sure that my use of the word courage is not misunderstood. In its ordinary usage, courage carries with it the notion of bold, brave, positive action. For some, its opposite is cowardice, timidity, lack of action. And describing courage as a virtue for a judge might be mistakenly understood as saying that a good judge is one who takes strong, aggressive action, heedless of the consequences. That's not my concept of judicial courage. In fact, it sounds more to me like arrogance than courage. Sometimes, in fact, the courageous thing for a judge to do is to refrain from acting in the face of public clamor to do something. Sometimes the exercise of restraint requires courage. So let me move on to judicial restraint. Courts adjudicate disputes, as you know, in an adversarial context. A judge is only supposed to decide based on the facts and arguments submitted by the parties. Without the extensive research available to policymakers and governments, a judge's insight into the broader social and political implications of a decision is limited to the record presented by the parties. I think restraint in public law adjudication is an exercise in humility which recognizes the limits of the court's decisional capabilities. Judicial humility can take many forms, but one is the willingness to respect the role of legislators and policymakers and to appreciate that we judges are neither legislators nor policymakers. Restraint counsels minimalism in deciding cases on the narrowest possible grounds, reasoning factually by analogy to precedent instead of articulating grand theories of political morality. It does this to avoid unforeseen consequences for future cases. Judicial humility also takes the form of respect for precedent. Chief Justice John Roberts has said that, quote, judges have to have the humility to recognize that they operate within a system of precedent shaped by other judges equally striving to live up to the judicial oath, unquote. In a court such as mine with 30 judges, all of them fine, experienced judges, those words resonate. We operate within a system of precedent shaped by other judges equally striving to live up to the judicial oath. At the same time, judicial restraint means respecting the legislator's law-making role and democratic legitimacy. It means showing appropriate deference to legislative sovereignty on public law issues, such as the scope of human rights and whether a statute reasonably limits a right. So now that these two virtues are on the table, let me say a little bit about their interaction. The need to balance courage and restraint poses a dilemma to judges. How do we uphold the rule of law without straying beyond the limits of our constitutional role? As I've said, excess of courage can lead to arrogance and thinking that we judges know better than the legislature about matters of policy, whereas excess of restraint can lead to timidity in the face of abuses of state power. There's no formula for resolving this dilemma. The reality is that it's fundamental to the role of a judge in our constitutional framework. And the dilemma isn't new for judges in Canada. It's one we've had to reckon with in both the pre-charter and post-charter eras. And I think we can depict the evolution of Canadian constitutional doctrine in the two eras in terms of this dilemma, and by looking at some prominent jurists in Canadian constitutional history as they've engaged in it. Let me turn to that discussion. In the pre-charter era, life was much easier for judges, I think. It was probably much easier for law teachers. Because in a sense, judges in the pre-charter era were more like impartial umpires between the two levels of government, declaring statutes ultra vires if they were outside the authority of the relevant legislative body. When I took constitutional law here, taught by the incredible Albert Abel, we spent virtually the entire year on Section 91 and 92. That was in 1973. And basically, we might have touched on fisheries and oceans and seacoast and inland fisheries, but it was basically division of powers law. But there were, and even in the pre-charter days, examples in which judges showed restraint and humility by refusing, for example, to adjudicate constitutional issues that did not arise squarely for decision. As Chief Justice Laskin said in the Anti-Inflation Act reference, if the legislation is sustainable as crisis legislation, it becomes unnecessary to consider the broader ground advanced in support, and this is because, especially in constitutional cases, courts should not, as a rule, go any farther than necessary to determine the main issue before them. So when judges in the pre-charter era protected human rights, they did so in rather a conservative and incidental way, maybe a very traditional way, for example, by interpreting statutes interfering with liberty in a very narrow way and requiring any such interference to be expressly authorized by law. They invoked the presumption, for example, that in the absence of a clear indication in the statute to the contrary, the legislature did not intend to affect the liberty or property of a citizen. That said, the effect of statutory interpretation for the protection of human rights was not always salutary. Indeed, in retrospect, we can point to cases in the pre-charter days in which human rights were violated as a consequence of statutory interpretation, where courts decided that the legislature clearly expressed an intention to interfere with liberty or property, no matter how unjustifiable that interference was. As I've said, judicial restraint and deference to the democratic legitimacy of legislatures was a central feature of pre-charter constitutional law, but this largely played out in the context of the Section 91 and 92 Division of Powers analysis. One notable exception, and really the judge I'd like to focus on in the pre-charter era, was Justice Ivan Rand, who I've already mentioned, who was appointed to the Supreme Court of Canada in 1943. Several of Rand's best-known decisions arose in the hot political climate in Quebec, particularly in the pre-World War II and post-World War II era, when the province sought to repel perceived challenges to its authority and to the authority of the Roman Catholic Church, particularly challenges by Jehovah's Witnesses and the perceived threat of communism to the democratic state. There was, of course, no entrenched Bill of Rights at the time to protect civil liberties, but courts still adjudicated in accordance with law, and they exercised powers to review legislation for its constitutional validity. Rand's civil liberties cases were framed in terms of whether the province had the authority to act limiting the rights of Jehovah's Witnesses and communists. To declare such laws ultra vires, I think, would require an act of judicial courage given the political climate at the time. Rand received his legal education in the United States and was exposed to the Constitutional Bill of Rights in that country. He also served as Canada's representative on the United Nations Special Committee on Palestine, which led to the creation of the State of Israel. He was obviously aware of developments in international human rights during his experience, and his civil liberties decisions were a product of that experience. Rand developed an innovative doctrine often called the implied Bill of Rights theory. The theory was that even though the Canadian Constitution contained no written Bill of Rights, legal limits on sovereignty were implied by the system of democratic governance inherited from Britain and by ancient civil rights held by citizens and recognized at common law. Let me give two examples from Rand's judgment. To set the stage for the first, in 1944, Premier Duplessis in Quebec began what he described as a war without mercy on Jehovah's Witnesses. They were arrested en masse, charged with seditious libel under the Criminal Code, and municipalities, including the city of Quebec, passed bylaws making it an offense for Jehovah's Witnesses, for a general offense to distribute literature without a license. In the case of Saumur in 1953, a Jehovah's Witness had been prosecuted under the Quebec City bylaw, which forbade the distribution of pamphlets on the street without permission from police. Rand held that the bylaw was ultra vires because it was legislation in relation to expressive and religious freedom, a head of power that was not within provincial jurisdiction. Freedom of expression, he said, is the breath of life of the political institutions of this country. In Canada, he said, quote, government is by parliamentary institutions, including popular assemblies elected by the people at large in both provinces and Dominion. Government resting ultimately on public opinion, reached by discussion and the interplay of ideas. If that discussion is placed under license, its basic condition is destroyed. The government as licensor becomes disjointed from the citizenry. The only security is steadily advancing enlightenment, for which the widest range of controversy is the sine qua non. The second case, called Switzman and Elbling, a decision of the Supreme Court of Canada, written by Rand in 1957, concerned the constitutionality of a statute enacted by the Duplessis government, referred to colloquially as the Padlock Law, which authorized the closure of any building used for dissemination of communist propaganda. Mr. Switzman wanted to sublet an apartment in Montreal for use as a communist meeting place. The landlord, Ms. Elbling, resisted his attempt to lease the property, fearing sanction by the province. She applied to have the lease canceled, and Justice Rand held that the Padlock Law was ultra vires. The purpose of the statute was to suppress subversive political expression, which was a criminal purpose under federal legislation. He stated that under the preamble to the British North America Act, quote, Canadian government is in substance the will of the majority expressed directly or indirectly through popular assemblies. This means ultimately government by the free public opinion of an open society, the effectiveness of which, as events have not infrequently demonstrated, is undoubted, unquote. As courageously innovative as Rand's implied Bill of Rights theory was, it cut against the grain of British tradition of legislative sovereignty. It was so novel precisely because the generation of lawyers and jurists to whom it was addressed grew up in that tradition. But eventually, in a case called Dupont in 1978, the Supreme Court explicitly rejected Rand's theory in favor of the legislative sovereignty tradition. The case is interesting to me on a personal level because it concerned a 1969 Montreal bylaw prohibiting public assemblies that would endanger public safety. I was, as you heard from the dean, I was at McGill as an undergraduate from 1967 to 1970. And I remember the demonstration that sparked this particular bylaw. There were a number of violent street demonstrations in Montreal during that period. It was wonderful for a student. You could go and there was everything to protest. The Vietnam War was in full swing. There were protests, riotous protests against the Vietnam War. There were protests against the Anglophone nature of McGill University, where I was a student. There was a protest at what was then called Sir George Williams University, now Concordia University, where the computer center in the university was occupied and burnt, protesting against racism at the university. In contradistinction to that, 1969, I think, was the year that John Lennon and Yoko Ono held their famous bed-in at the Queen Elizabeth Hotel. But they were tumultuous years. There were almost incessant marches on the streets of Montreal, tying up traffic and irritating Mayor Jean Drapeau. And in Dupont, Justice Betts held that the bylaw was not an unconstitutional encroachment on the federal government's constitutional jurisdiction over criminal law. He rejected the argument that the bylaw impermissibly infringed the fundamental freedoms of expression, assembly, and association, stating that none of these freedoms were so enshrined in the Constitution as to be above the reach of competent legislation. So the rise and fall of Rand's Bill of Rights theory is a manifestation of the dilemma that judges faced in the pre-charter era between showing the courage to invalidate laws that infringed individual rights and the pressing need to show restraint in deferring to the equally important democratic sovereignty of legislatures. As a footnote, it seems the dilemma seemed to continue to exercise Justice Betts, who after Dupont actually accepted something like Rand's theory in Opstiu and Ontario when he wrote that the basic constitutional structure of the British North America Act established democratic political institutions that derive their efficacy from freedom of expression. So let me turn to the Charter era, where I think that constitutional doctrine can again be depicted in terms of the challenges of balancing between judicial courage and restraint, even though these challenges play out somewhat differently. As you know, Section 52 of the Constitution Act gives courts a responsibility to declare a statute inoperative if it is inconsistent with the Charter. In this respect, to state the obvious, the Charter was a game changer. Determining whether a statute limits a Charter right requires an interpretation of the scope of the right. This is quite different from a court's pre-Charter consideration of common law rights, which was only incidental, as I've said, to the functions of interpreting statutes or reviewing legislation for compliance with the division of powers. As Chief Justice Dixon stated in Hunter and Southam, expounding a constitution is different from construing a statute. Charter rights must be seen as, quote, capable of growth and development over time to meet new social, political, and historical realities, often unimagined by its framers, unquote. Those rights must be interpreted purposively in light of their animating values and interests. Interpreting charter rights is a judicial task that goes well beyond the interpretation of common law civil liberties. It calls on judges to expound moral values consistent with contemporary social and political realities. I might say in a discussion today with one of my colleagues about this speech, she pointed out that the judges face another challenge, and it was a good point. Her point was that judges risk losing their legitimacy if they get too far ahead of contemporary social and political realities. There's a danger that we, in attempting to move the law forward, particularly in the area of the Charter, that our decisions do not, in fact, even though we may think they do, reflect current political and social realities. The legitimacy of protecting civil liberties at common law came from traditional practice originating in Britain. By contrast, the Charter's legitimate authority comes from its democratic enactment by elected representatives. Charter rights express the moral values held by Canadian citizens. Instead of leaving judicial consideration of rights as an incidental function of public law adjudication, the Charter directs judges to venture forth into the realm of political morality to assess the consistency of legislation with prevailing norms, even if doing so places them at odds with legislators' views about these norms. Chief Justice McLaughlin has written that in the Charter era, quote, there is no way to interpret the Charter without making value judgments, unquote. She says that a major challenge that judges face in Charter adjudication, quote, lies in the impossibility of avoiding value judgments in Charter decision-making. Value judgments are inherent in defining the scope of rights and freedoms guaranteed by the Charter. I would add that this challenge requires the exercise, at times, of both judicial courage and judicial restraint. Once a judge defines the scope of a charter right and concludes that it has been limited by the statute, he or she must ask whether the limit is justified under Section 1. But no limit, no matter how justified, satisfies Section 1 if it is not prescribed by law. Thus, under Section 1, judges of the Charter era must determine whether a limit on rights is legally authorized. Unlike in the pre-Charter era, however, Section 1 directs judges to scrutinize the state's justification for limiting a charter right, even if the limit is unambiguously prescribed by law. It instructs judges to depart from total deference to legislative sovereignty and determine whether a rights infringement is proportionate. The inquiry into the justification for limiting the right also calls for judicial courage. It requires judges to confront head-on the difficult value judgments implicit in balancing the beneficial effect of pursuing pressing and substantial state objectives against the detrimental impact of limiting a charter right. This is quite obviously a novel role compared to the role exercised by judges in the pre-charter era. Although the proportionality element of the Oakes test means that deference to legislative sovereignty is not absolute in charter adjudication, judges, in my view, must still show restraint, humility, and respect for legislative choices in the Section 1 analysis. In charter adjudication under Section 1, courts must have the humility to acknowledge that when it comes to addressing the demands of competing constituencies in polycentric decision-making contexts, legislators have better expertise and the resources needed to put complex social policy research into action in the most reasonable fashion. Similarly, courts should show respect to the legislature's reasonable choices in this regard, supported as they are by the democratic lawmaking process, such as choices about how best to trade off competing charter interests when acting so as to protect vulnerable or disadvantaged groups. My colleague, Justice David Doherty, recently spoke at a symposium in honor of Justice Mark Rosenberg, who was a beloved and revered former member of our court. He discussed Justice Rosenberg's philosophy of judicial restraint when deciding cases, including charter cases. And to appreciate these remarks, you really have to understand that Justice Rosenberg might well be the preeminent criminal law jurist, Canadian criminal law jurist of this era. But Justice Doherty pointed out that Justice Rosenberg preferred to decide such cases, charter cases, only on the narrowest grounds that squarely arose for decision. He preferred to avoid sweeping pronouncements of what he thought the law should be, favoring careful analysis of what the law was, and never veering far from precedent or the facts of a case. And if there's anyone in the country who had a better right to know what the law ought to be, it was Justice Rosenberg. Yet, in criminal law at least, yet he favored a careful analysis of what the law was and never veered far from precedent. One example that Justice Doherty mentioned was a decision in a case called Wakeford and Canada in 2002, in which Justice Rosenberg co-authored with Justice McPherson. The appellant challenged a provision of the Controlled Drugs and Substances Act that authorized the Minister of Health to exempt him from criminal liability for cultivating and using medicinal marijuana, claiming that it infringed Section 7 of the Charter. He also challenged a provision that exposed his caregivers to liability for possession and trafficking in marijuana. That case might well have presented Justice Rosenberg an opportunity to comment on the draft regulations made by the federal government to deal with earlier charter cases that Justice Rosenberg had authored on the criminalization of medicinal marijuana. However, Justice Rosenberg dismissed the appeal on narrow grounds, declining to comment on the policy issues it raised, and deciding only those questions that arose squarely for decision. He held that the federal court had exclusive jurisdiction to consider the constitutionality of the legislation. The appellant lacked standing to seek a charter remedy for violation of the rights of his caregivers. And because the draft regulations sought to be introduced as fresh evidence would not affect the outcome of the appeal, he refused to admit them. This was indeed a studied minimalist approach. According to Justice Doherty, Justice Rosenberg's judicial restraint was a product of his self-discipline. He was able to separate his conception of the law as it ought to be from his conception of the law as it was, which he reached by searching for and applying neutral and objectively determined principles to specific fact situations. Justice Rosenberg's judicial restraint was also a product of his humility. He recognized that to be legitimate, all authority, including judicial authority, had to be strictly constrained, and that the power he wielded must not be abused. To achieve this goal, he insisted on focusing on the specific facts of the case and having the outcome dictated by the application of accepted judicial methodology, even if the result in certain instances was contrary to his own personal views. Now, to briefly illustrate that the challenges that judges face in negotiating the competing demands of courage and restraint in the post-charter era, I want to mention one last jurist, Peter Corey, Justice Peter Corey. He served as a judge of the Supreme Court of Canada from 1989 to 1999 and had been a trial judge in Ontario and a judge of the Court of Appeal for a total of some 8 years. When I was a student at this law school in the early 1970s, I had the very good fortune of working for Justice Corey when he was a practicing lawyer for 2 summers. The stories of Corey's humanity and humility are legendary. I won't go into all of them now, but I can say that behind his mild, self-effacing exterior, there was a backbone of steel. During the Second World War, at the age of 25, he served as a pilot of Lancaster bombers and flew a total of 22 combat missions. If you want to learn something about his courage, you should read the story of what he did after he became a judge, when he was hired by the British government to investigate collusion by British and Irish security forces with the IRA. It's a chilling tale and a case where Corey exhibited not only mental courage, but physical courage. But let me mention just one of Corey's charter decision, Askov. His reasons in Askov and his later comments on the decision's implications for the justice system offer an illustration of the judicial challenges I've been speaking about. As you all know, Section 11B of the Charter guarantees to accused persons the right to trial within a reasonable time. Askov involved 4 accused who were charged with conspiracy to extort and were set to be tried in Brampton in the Ontario Judicial District of Peel. They experienced almost a 2-year delay between the preliminary inquiry and trial because of a lack of available courtroom facilities in Brampton. In those days, and perhaps even today, Peel was known as No Deal Peel because the Crown attorneys were tough and they would not agree to plea bargains in cases. They would force counsel and their clients onto trial. The result was predictable. The court's docket was clogged with pending trials, and the delays got worse and worse. Justice Corey suggested that the delays in Peel were longer than any other jurisdiction in North America. It was clear that in the case that if the court found that the institutional delay was unreasonable, it would have far-reaching implications for the allocation of public resources to the province's justice system. Bluntly, If the cases were thrown out to delay, it would mean there would have to be more courthouses, more Crown attorneys, more court staff, and probably more judges. But Justice Corey did not shy away from these ramifications, and he proceeded to interpret Section 11B generously in accordance with its purposes. He described the delay awaiting trial as, quote, exquisite agony, unquote, for accused and their families. Furthermore, he said that long delays in calling an accused to account to the community undermine public confidence in the judicial system. Such was the importance of Section 11B that the lack of institutional resources could not justify the continued unreasonable postponement of trials. He recognized that some judicial deference had to be shown to government choices about the allocation of resources, but he concluded that the province had to find the solution, and the burden could not be put on accused persons. Justice Corey seemed to be aware of the public backlash that would and did follow his reasons, but he held steadfast, writing, quote, it is those who are responsible for the lack of facilities who should bear the public criticism that is bound to arise as a result of the staying of proceedings, which must be the inevitable consequence of unreasonable delays. And indeed, the consequences of ASCOV are well known. Between October 1990 and April 1991, tens of thousands of charges were dismissed or withdrawn on the basis of the decision. In July of 1991, less than a year after ASCOV was released, Justice Corey was speaking at a conference at Cambridge University in England. He stated, perhaps thinking he was off the record, that although he knew ASCOV would have an impact, quote, quite frankly, we, the Supreme Court of Canada, were not aware of the extent of the impact, unquote. Perhaps with the benefit of hindsight, I'm not sure that I think so. He may have thought that it would have been appropriate to show more restraint than he did in ASCOV. It did not take long for the Supreme Court to rein ASCOV in, and in 1992 it released Morin, which would temper the effect of ASCOV. Interestingly, Justice Corey did not sit on the Morin appeal, perhaps because he felt that his remarks at Cambridge disqualified him. I'm not sure that he intended his remarks for public attribution. They probably were not. But the fact that he made those remarks is, for me, an act of both humility and an act of courage. So let me conclude. I said earlier that balancing courage and restraint poses a challenge to judges. Part of the challenge lies in recognizing when each virtue is necessary and when it is not, and in negotiating the path between the two. Perhaps my use of the terms courage and restraint and describing them as virtues creates its own challenge. As I said, courage can connote something positive, bravery. Restraint has negative implications, a break or a burden. But adrenaline-fueled courage is sometimes foolhardy, and the temptation to do the courageous thing can lead to overreaching. Sometimes, as I said, it takes courage to show restraint. The easy road may be to strike down seemingly offensive and unpopular legislation, but it may be more courageous to find ways to save some or all of the legislation. The Charter unquestionably requires more of judges, and in return it gives judges unprecedented authority in respect to legislation. But to paraphrase Justice Doherty's tribute to Justice Rosenberg, the abuse of judicial power is just as bad as abuse of any other power, perhaps worse, in fact, because elected politicians can be voted out of office. And if the point of judicial independence in both its institutional and subjective dimensions is to curtail the arbitrary abuse of power, we judges must exercise self-restraint in the use of our own power and have the self-awareness and courage to guard against its potential for abuse. We must be cautious, frankly, in perceiving ourselves as courageous when we are in fact being overzealous. By the same token, restraint can be both a virtue and a vice. Restraint, in the sense of deference to wisdom of elected lawmakers, is a virtue, but not when it's exercised in the face of unjustified infringements of rights and freedoms. My own view, and in fairness, I've got a few years left, so I can't say it's a final view, but my own view at the moment is that our duty as judges is best performed by performing the case in front of us. We're not royal commissioners, and we're certainly not legislators. Like Justice Rosenberg, I think we should strive to exercise restraint and decide what is necessary to resolve the case and no more. To quote Chief Justice Roberts once again, if it is not necessary to decide more, it is necessary not to decide more. If it is not necessary to decide more, it is necessary not to decide more. Thank you very much.
Strathy will take some questions. We just have microphones on either side of the room if anyone wants to step up and ask a question.
Well, Chief Justice, thank you very much for that. I really enjoyed it. I especially enjoyed the fact that you recognized that we actually had a constitution before 1982, which many people don't seem to. And you clearly seem to be very interested in Ivan Rand. So I'm curious to hear a little bit more about your views about where he got his ideas from. I mean, one hears, I think, a couple of incorrect versions of where Rand came from. One was that Rand had to decide in those cases whether he hated the Jehovah's Witnesses more than he hated the French. And Rand did hate French, particularly Quebec and Duplessis and the rest of it, and had many other instances in his life where he really showed some animosity towards French Canada. So some of his critics argued that was behind those decisions. His biographer, Bill Kaplan, seems to put it all down to the fact that he spent some time at Harvard and had read the Bill of Rights, and that seems to me to be just simply too shallow. Do you have a sense of where he got his, I mean, he's a remarkable judge for his time, and the implied Bill of Rights doctrine is a remarkable doctrine for his time, but what's your sense of where he got those ideas from?
Well, the one I mentioned in my remarks is his exposure to United States constitutional law. I did not go into some of the, I referred to briefly to some of his own personal views. I've heard versions that suggest that Mr. Kaplan was a bit unfair to Justice Rand in his attribution of certain views to him. But the sense I have is that it was both his exposure to the United States constitutional law, which makes sense to me, and his broader experience with Israel. But do you have any suggestions on that? I don't think you would have asked the question unless you had a view on it.
You obviously read a lot of his judgments. I actually think that there's a need to look into the kind of Methodist duty that he also had, which was very important, and it's a sense of his notion of the collective, because in other parts of his major contributions to Canadian law, for example, the Rand formula, he actually believed a lot in unions, which is quite surprising for his upbringing. So I think there's something more subtle than that, and nothing about what he says in the implied Bill of Rights cases is easily traceable back to the US Bill of Rights. It's not the kind of Jeffersonian Enlightenment ideas of the late 18th, early 19th century. It's much more of the sort of almost British Fabian socialism kind of set of ideas, Methodism, that I think is that Kaplan did not investigate sufficiently, in my view.
Thank you. Any easier questions?
This is easy because I'm not a public lawyer at all, but as an outsider, one of the puzzles to me is an understanding of the role of the notwithstanding clause in all this. I mean, it's kind of interesting that it's never used. And I'm just wondering to what extent that influences your thinking about what courage and restraint means, when ultimately, at least for a number of matters, there's this kind of hammer in the back pocket that the legislature still has. Just wondering to what extent either you think that has an influence or it has no influence or it's just accepted, it's never used, so we shouldn't think about it. Just curious to if you have any reflections on that.
It's, I would have to say, I certainly should have begun all my remarks by saying that I speak only for myself, as we say in the Court of Appeal, but I would have to say that I don't think it enters into our consideration at all. It certainly hasn't entered into mine. That you know, I think, as I said in the course of my remarks, I think we try to do the job that we're given to do and let the chips fall as they may. And I think it's like it's not exactly the same, but you know, do we think of the fact that our decision may be appealed to the Supreme Court of Canada? We don't, and I don't think we think about the notwithstanding clause either. We know it's there, and it's the province of the legislature to decide whether to use it or not.
Chief Justice, my question would be, you've done a fabulous job of demonstrating the sort of tension between the two concepts of restraint and courage and the model of judiciary and the judicial temperament. What I'm curious about is, obviously, the way you've described it sets a pretty high standard for all of the judiciary, and one would think that you have to get there once a person is appointed, that there are various stages. It's a developmental thing that one would expect. Looking back, not commenting, of course, about anyone who's currently sitting, but historically, it must be possible for you to be able to look back on judgments and be able to say, yes, that was a relatively new judge. And that was a judge in the middle years. And that was a judge with a certain level of maturity and perhaps a touch of judgeitis. So perhaps you could describe to us anything you've observed in terms of not just the paragon, but the developmental process in the judiciary.
It's an interesting question. I was thinking about it in the course of my remarks because that first case I did, the Justice of the Peace case, I had just come back from what's colloquially called New Judges School, where they send all new federally appointed judges to a course on judging, a week-long course, well, actually 2 week-long courses. And so I was basically just, you know, shedding or just putting on my new robes before I dealt with that case. You know, I think people mature as judges just as they mature as lawyers, just as they mature as people. And I mean, it almost goes back to that you don't lose the qualities that you had as a lawyer when you're suddenly appointed a judge. You know, if you were a lawyer who was given to extravagant opinions, there's a risk that you'll be given to extravagant opinions as a judge. And I guess you try to weed out the really extravagant and unconstrained opinions when you're selecting people for appointment as a judge. But you know, I'm not sure that I quite agree with you that you know, I could pick up a judgment without knowing who the judge was and say, well, that's a judge in their early years. I can probably read the judgment and say, you know, this is a judge who knows where she's coming from or who's thought carefully about the case. But I have to say, you know, And part of my job as Chief Justice is to sort of watch over what goes on, not in any governance sense, but as an observer, watch what goes on in all our courts, our trial courts, the provincial court, the Superior Court, and the Court of Appeal. And I'm day in, day out impressed by the diligence of our judiciary. You know, like any other field of endeavor, we have our challenges, but I'm really impressed on a daily basis of how they go about their work. Haven't entirely answered your question, but thank you.
Chief Justice, thank you for a very eloquent lecture. I'm a teacher of constitutional law, and I teach Rand's wonderful judgments as much as I can. And one of the things that I think is somewhat different from my understanding of Rand's judgments is that he was so creative and went so far beyond what he had to decide, even within his very particular view of how federal and provincial powers fit together in a puzzle. So when there was a federal encroachment on what he thought were fundamental freedoms, he read down the legislation. And when there was provincial legislation that went in the same direction, which he opposed very much, he would strike it down as not falling within provincial jurisdiction and properly exercisable, if at all, under the criminal law power. Now, that combination seemed to maintain fidelity to the traditional idea of legislative supremacy. But in a letter that Rand wrote after he had retired, in response to a question from an American who had the audacity to ask the question that I suppose many people here wanted an answer to but didn't have the courage to ask him, he responded to the question whether he would have struck down federal legislation. And he said he would have. And of course, Justice Abbott himself, I think the only judge on the Supreme Court at the time, said that these principles applied to restrain both federal and provincial power. Well, if that's the case, we're in a really different kettle of fish. And that seems to me something a line of thinking, of creativity, and a reconceptualization of what was generally understood as our constitutional inheritance from Great Britain, that goes beyond your idea of what a judge should do or how a judge should think. He was actually elaborating a completely different theoretical framework and institutional framework for the understanding of Canadian constitutional law. Also on a smaller scale, but it would have been equally as radical, I suppose, he wrote an article on the Canadian Bill of Rights laying out every progressive step that the American Supreme Court had produced under its Bill of Rights in the post-war period under the Warren Court, and saying that's what the court should do under the Canadian Bill of Rights. And we all know that history went in the opposite direction. So I wonder whether he was actually a more creative, courageous, conceptual judge than can be accommodated in your framework.
That he goes beyond it, you mean?
Yeah.
Yeah, I'm not, the way you put it, he would be well beyond it. I mean, I'm not sure I can say more than that, really. What's your answer to your colleague's question?
Well, he was certainly playing to his own music. There, I mean, I wouldn't be surprised if it came from some sort of non-legal, non-political source. I mean, I respect Jim Phillips very much as a legal historian, and I think when I think of other great creative judges in Canada and elsewhere, a lot of them did have a very particular religious upbringing. I think of Laskin, I think of Dixon, of Bertha Wilson. So it could be that you need some sort of other comprehensive vision and the political morality that you derive from that to be as creative as those judges were in trying to really think about what it is to have not only a majoritarian democratic system, but a system of free and equal persons. So I think that what Jim has suggested should be investigated thoroughly. I think that's the best hypothesis that I've heard so far.
Thank you.
Chief Justice, my question will bring us out of the history a little bit and into the present and future. I think constitutionally and in terms of public policy, one of our biggest challenges right now can be found in the word reconciliation. And I'm just wondering how you might put your framework of courage and restraint and comment on what may face our judiciary in the coming years in terms of helping to further that concept and both in terms of what may become before the bench, but also just in terms of Canada's constitution.
It's a topic I have thought about, and the common strand I would take or would pick out of my remarks in relation to reconciliation is humility. I think having the humility, and I'd say both as a judiciary and as a society, having to recognize, having the humility to recognize what we've done wrong, having the humility to confront the issue, having the humility to recognize other people's experiences and what they went through to get to where they are today, and to engage in a respectful dialogue about how we can address the injustices of the past. I was at a conference in the North near the end of last year talking about the principles of Gladue, and the notion that we look into, certainly in the criminal sentencing field, that we look into the experiences of the individual, the particular Indigenous experiences of the individual going back many generations to what brought the person before the court. And I think if in our relationship with Indigenous peoples we can bring a sort of, if I can call it, a Gladue spirit to the approach, a spirit that recognizes how we've got to where we are today, that is a very good starting place. I don't, it does, it ties into, for sure it ties into humility. I think it turns into, ties into humanity, which is another judicial virtue that I would say is particularly important for judges to have, and we need to approach those issues with humanity.
Thank you for your comments, Chief Justice. You mentioned Justice Rand and his familiarity with the American Bill of Rights, which always struck me as a very modern, in a sort of historical post-war sense, a very modern document. And then, of course, Justice Corey's comments about our own Constitution and how it should be interpreted as a growing, living tree, as we now usually call it. And I just wondered if you had any comments about the divergence between those two views, which always sort of amazed me, that the Americans have gone quite the other way in terms of their very robust Chartist perspective, whereas it seems to me from the beginning we've had a similar growth and evolutionary model, which has never really been challenged, at least in the Canadian jurisprudence. So I just wondered if you had any comments about that.
Yeah, I don't know what it is. I just don't get the originalist theme. To me, society changes, laws change, institutions change, and the law has to evolve, and the Constitution and our interpretation of the Constitution has to evolve. So, to me, the living tree, the development of the law, the ongoing interpretation of the law makes far more sense and is far more satisfying as a way of a way of adjudication, a jurisprudential theory. To me, I don't get it. Okay.
Chief Justice, I want to thank you for what might be in this sort of academic setting, a bit of a provocative start to our series. By reviewing the constitutional cases both before and after the Charter, you've reminded us of the importance of the role and the values of our judiciary and how important it is that we choose well for the people in those roles. I hope that our subsequent speakers can pick up on the themes of judicial courage and restraint as we examine the seminal cases, and I want to speak a little bit about the series before I ask you to join me in thanking Chief Justice. But so the Asper Center is this, as you heard at the beginning, we've launched our sesquicentennial Constitutional Roundtable series, and looking at the development of Canada's constitutional and human rights from the British North America Act to the Canadian Charter of Rights and Freedoms. And the series includes some papers that provide an analysis of some of these seminal cases. February 9th, we have Hugo Cyr, and I just have the titles, so I'm sure it doesn't give you very much background, but you'll see that on our website, Normalizing the Exception in Canada. On March 1st, we have Richard Haig talking about the Alberta Press case, so a pre-charter case. And on March 22nd, we have Jamie Cameron talking about Section 7 and the idea of the Charter. But this has been a very excellent start to this series that is focused on case law, and I want to thank you and ask everybody to join me in thanking the Chief Justice for your thoughts.
Thanks, Cheryl. Thank you very much.